Well, this is the second document filed today. United States District Court, Eastern District of Wisconsin. Andrew Colborn versus Netflix, Chrome Media, Synthesis Films, Lord Ricardo Moradimos. Motion leading to bar admission of opinions and statements of plaintiff's counsel at trial. Please take notice that the plaintiff, Andrew Colborn, by and through his undersigned counsel, hereby moves the court for an order excluding from admission at trial in this matter are personal opinions of any of his counsel expressed prior to commencing representation of plaintiff, and 2. Any alleged prior statements or testimony by his counsel relating to any matters connected to Stephen Avery prior to commencement of his action, and that are merely recitations of the hearsay, or that, based solely on hearsay, in support of this motion, plaintiff alleges and shows court as follows. Oh, great. Based on statements in the recently filed motion to compel defendant Netflix Incorporated openly seeks to embarrass one of the plaintiff's attorneys, Michael Griesbach, with prior statements and personal opinion that Netflix contends conflict with plaintiff's position in the case. Attorney Griesbach's personal opinions and any issues of Stephen Avery and legal proceedings, including him, that were expressed prior to being retained to represent plaintiff, involve statements made outside of Attorney Griesbach's professional capacity. Sorry. As an assistant district attorney for Manitowoc County, Wisconsin, are admissible lay opinion that cannot be admitted in trial of these proceedings. Further, Attorney Griesbach's personal opinions, to the extent not based on his own perception of events, are irrelevant as they do not tend to make any facts an issue more or less probable than it would be without evidence. Unless defendants are conceding that the Attorney Griesbach is competent to serve as an expert witness regarding material fact as an issue in this case. Any of Attorney Griesbach's prior statements or testimony regarding any matters connected to Stephen Avery that are merely recitations of hearsay likewise cannot be admitted at trial. Netflix actions in attempting to threaten one of plaintiff's attorneys that he may be called to testify at a trial and attempting to subpoena materials that are publicly available but are gathered by one plaintiff's attorneys for personal reasons are harassing to plaintiff and to interfere with the choice of counsel in these proceedings. Most states' rules of professional conduct for attorneys contain some irritation of the principle in representing the client. A lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden the third person. By serving Attorney Griesbach with a subpoena in his personal capacity, Netflix has practically admitted that Attorney Griesbach is a third person to this case as to his personal capacity. The matters proposed to exclude are inadmissible at trial. Any order so holding at the juncture would allow the parties to focus their preparation and resources in pretrial proceedings to those that are likely to bear material issues instead of expending time and effort to wasteful exercise that are harassing to plaintiff and his counsel. So basically, Andrew Colborn doesn't want Michael Griesbach to dissolve any of the information used to write all three of his books and anything else discussed prior to him becoming Colborn's attorney, which would back all the way up into 2018, October, because that's when, well, I assumed this was coming eventually, but I thought it'd be a lot sooner, not 2 days before they're supposed to submit everything. So I'm sure it'll be eventful in the next couple of days, and see y'all next time.